Welcome back to the channel, and thank you very much for watching. As promised, we have a video for you to break down yet further the Vardy and Rooney trial and some of the details within that. And to do that, I have back with us again, give a warm welcome back to Alan Robertshaw. How are you doing today, Al?
Very well, thank you. Yes. Just to say, I actually prefer the Scouse trap.
Indeed, indeed. So this trial, I did a video earlier today. For those that haven't caught it, will be linked in the description below. But for those that don't want to watch that first and want a brief overview, I've done it once. So let's take your version. What was this trial all about, Al? What were people complaining about in this trial?
Well, I think what people found interesting, the basic nub of this is that Colleen Rooney was concerned that somebody in her circle was leaking private personal information to the newspapers. And she engaged in quite a bit of detective work. She realised she narrowed it down to people in her sort of Instagram group, her private Instagram group. And what was really clever is she narrowed down the number of suspects, but she also created fake stories that were really, sort of very appealing, the sort of thing people go, oh, wow, this is very newsworthy. And what's interesting is she independently invented a trick that actually MI6 invented, which is they do a thing where they write different versions of reports and they put in various key phrases and they write them in the way that'll be really quotable, so that if any spies are leaking anything back, they will
know where it came from.
Yeah, but they use different combinations of the quotes so they can narrow it down to one particular document so they know who leaked it.
Yeah, it's very clever.
It's really clever of it. And one thing that came out in the trial, because this was put as a question, which was, you must have done this with other people, or you must have told other people about this, and they could be the source of all this information. And she said, no, I did, and it was fully accepted that she did this on her own. Wayne Rooney had no idea that this was going on.
Well, she did say that she found it really difficult to keep it to herself, and I think that's really interesting. I mean, most people would be chomping at the bit to tell someone that they've come up with this trick and found out, but ultimately, she said she kept it to herself, and that's how she narrowed it down. So, yeah, essentially highlighted who it was that she said was leaking these stories to the papers, no doubt selling them. I mean, I don't know what stories go for these days, but it depends on who they are and what it is, doesn't it? But papers certainly pay for it because they want to publish it. So, what else were you going to say?
Well, one thing I was going to say is, now, it's clear that, she did this on her own. Do you know we talk about like libel pre-reading and checking things? This could all have been avoided with just a little bit of tweaking of the wording. And you did a really good explanation as to what the meaning was. We've just gone back and, we've discussed previously, like it's up to the judge what the meaning is. And Rooney's defence team contended a meaning that was sort of quite wide, which was effectively, we're not saying it's her, but it's somebody who had access to her account. And the judge said, well, no, the meaning is it's her. Yeah. And this is interesting because although there's the ... it's Rebecca Vardy's account, which seems to make it wider, what people miss is before that said there's only one person this could come from. Had she have said there's only one place this could have come from, Rebecca's Vardy account, I don't think we'd be here.
And that's an interesting point, because actually I noticed one of the comments to the previous video was the account could have been hacked. This doesn't prove anything. But this is exactly the point, isn't it? Because the meaning that was attributed was that it was her, as you say, not the account. So it's a very good point, but moot in the sense that the meaning overrode that assumption that it could have just been the account. And as you say, if that's lost on anybody, because I learned about this as well from Al as we discuss it, if this had just have been the account, and that's what she said, it came from the account, then the defense could have been that the account could have been hacked and whatever, and it's no proof that it was her, and so on and so on. Yeah, it changes things, doesn't it?
Yeah, and like I said, this is all the thing in defamation, where you can usually get exactly the same tone you want in a story, but tweak the words to make it safer. And oh God, I mentioned that trial again. That trial where there were two versions of the offending article, and I said before that, had that have come to me when I was doing the night lawyering, I would have said, oh, actually, dial this back a bit, stick that in there, and you're safe. And ironically, that's what they did for the second version of the article.
It was tweaked, wasn't it?
Yeah.
Yeah. So no, that's really interesting. So we also have to take a quick squiz at the judgment here. So as always, it's a fairly lengthy judgment. You can see we've got the index here, runs into hundreds of pages. So you know it's a long judgment when they've got to put an index in there. And so meaning, there is a natural meaning that was agreed. If I search for it, that will pop up.
Yeah, it's very near the beginning.
Yeah, single, there we go. Single natural ordinary meaning. So this is just what would, and I also want to pick up on something that I also picked up in the comments. Someone said that it was disparaging or disrespectful to say the ordinary person, as you referenced before. But just to clarify that, what we mean is, as Al said before, you know, lawyers and judges are told not to think as lawyers and judges, just told to think of someone who is not legally trained, not looking at the legal meaning, the legal definition, or the case law and all this sort of stuff that's behind it. What would any member of the public ordinarily believe this to mean? That's what we're talking about, isn't it? So we're not, you know, neither of us are being disrespectful by saying, you know, the ordinary reasonable reader. What we mean is someone who is not trained in law, who's not going to say, aha, this word means it's not the same thing. And that's what we mean.
An omnibus was the traditional test. And you still hear that used in law, you know, or the person on the Clapham omnibus, as it would be now.
Exactly. And so there we have it, the single. And so this would have gone through... I mean, this might have been agreed, might it, Al, or it might have gone... Well, actually, no, it was at a hearing, wasn't it? It was at a hearing. So it might have been that it was agreed at the hearing and bounced between them, or it was the judge that said, no, this is what it means.
Yeah, it's Rooney's team. It's just below, actually. It's listed just below that. Rooney's team put in a much broader thing, which would have been a much easier thing to defend and a much harder thing to prove. You know, that's what people do. What you always find is that the defence always put in a meaning that's really easy to defend, and the claimant always put in a meaning that's really hard to prove the truth of. You know, and that's happened. You see that happen a lot in trials where, and that's why we have this. Of course, the whole point of the judge saying, here's what the meaning is then the defence know what they have to prove the truth of. In the old days of juries, meaning was left to the jury because, you know, they are by definition the people who the test is aimed at. You know, what do ordinary hypothetical readers do? You don't need
the ordinary reader and in the case of the trial, the finder of fact. Absolutely.
Yeah, but often you didn't. The trouble with juries is you didn't know what you had to prove because you would argue and say, we say it means that. The other side would say, well, we say it means this. It was up to the jury, and you do this just to get technical again. What we'll quite often do is you'll put in the meaning you say it means, and at the same time you'll put in what we call Lucas box, again named after a case, meanings. You say, this is the evidence I would use to defend the meaning I'm putting forward. Here's my Lucas box defence. I can, you know, if you agree it means that, well, I can prove it means that by these facts. And then it, you know, all hangs together. And if the judge is with you on the meaning and also agrees with you that the evidence justifies that meaning, you can deal with it very, very early. And in defamation, there is a lot of pressure to settle early. I mean, most civil claims settle. Defamation claims, there's even more pressure to settle. There's probably 1% of claims get to court.
Yeah, and the newspapers have sort of estimated the costs in the region of £3 million as in legal costs. What do you think? Is that anywhere near accurate in your experience?
Yeah. Because there's a lot of preliminary skirmishing in this, and all those here. So we've had some idea of the costs, and the people were charging, you know, specialist defamation rates. And what you do in any case, but especially in defamation, we started. It happened first in defamation cases, which is you put forward a cost budget at a very early stage in the proceedings, and you have to get the judge, or actually a special type of judge called a master, to sign off on the budget and say, okay, this is how much I'm going to allow you to rack up. And that's been expanded now to all civil litigation. But, you know, we were the first because of course we were notorious for sort of stupid cost building. But it doesn't surprise me. Cost is going to be the big issue in this case.
Yeah,
because
no doubt.
we know that there were offers to settle. Now the usual rule in England and Wales is loser pays winner's costs. Mm-hmm. And obviously Rooney's won, so it's for Vardy to pay. But there are ways around that as well. If they've been without prejudice settlement offers, without prejudice means the judge doesn't get to hear of it until after the trial. So you can say anything without prejudice hearing. Say, okay, we admit it. How much would you take to go away? Yeah. But then if it goes to trial, they don't accept the offer. You can't say, well, they admitted it in the conference.
Yeah, no, exactly. And without prejudice is something that a lot of people misunderstand with great respect. But communication, which is a genuine attempt to settle the matter, is deemed to be without prejudice, whether it's marked or not. And the reverse, if something's marked as without prejudice, but there's threats in there, then the without prejudice disappears, and you can bring it to the court and say, look, they're being really badly behaved here. This goes against them for costs, not for the case, almost invariably not for the case, but certainly when it gets to costs. So if they're making sort of bullshit threats and arguments and being really, badly behaved and rude, that generally, again, comes back to bite with costs. And mediation is notorious for without prejudice, so you can't do a mediation and then come back later and say, well, at mediation they were willing to settle for this much, with judges like, I don't want to hear it. Yeah. And won't hear it and won't consider it, and it won't impact at all. So you touched briefly on the defences, so we come back to here. I've bookmarked, there's two defences they run by the look of it in this.
They did. They ran truth and public interest.
Indeed.
Very interesting. And if you wanted to spin this, if you're a spin doctor, I would be saying, if Rebecca Vardy should be saying, we wanted to prove this wasn't in the public interest, and we succeeded, because although Rooney succeeded, spoilers, on the truth defence, she failed on the public interest defence.
Indeed.
And we'll come to that in a moment as to why that was, or whether that actually really went anywhere.
So running with the truth, substantially true, as we've discussed a number of times on this channel with respect to various trials of late. So substantially true, we need to prove it's a statutory defence, was a common law defence. In fact, they were both common law defences, weren't they? But they are both codified sections.
Truth used to be called justification. I mean, one thing that is quite useful in the 2013 Act is that they gave everything, because we know we've said like malice means something different now to what it used to mean, and that's why it gets confusing. What they did in the Act is they brought all the language up to date. So it is now truth, whereas previously it was called justification. And it actually says it's the common law defence of justification is abolished.
Yeah. And so there it is. So proving that it was substantially true. So she would, in her defence, the statutory defence, she had to set out to prove that the meaning that was bounced around and ultimately ruled by the judge, that meaning of the wording was substantially true, so that her complaint, if you like, that someone was leaking these stories to the press and that she made a post about it to say she's done her digging, done her sort of personal espionage and figured out who it was that was doing it. That was what she had to prove the truth of substantially to run this defence. And the second defence, public interest.
But just to get back to the truth defence, what was interesting is that towards, we'll talk a little bit why the trial was just, the wheels fell off and it was a disaster for Vardy. But what was interesting is it became clear that actually it was her sort of personal assistant who was actually doing the donkey work in terms of contacting people and being the go-between. And remember that original thing on meaning, we're going, no, you've got to point the finger at Vardy. Well, what they actually argued in the trial and said, well, look, we appreciate what you're saying about meaning, but you've got to apply agency. If she is fundamentally directing somebody to do something on her behalf, that should count as her doing it. Because otherwise, if you'd have got somebody else to type it out or somebody else to press send, then arguably that would have got her off the hook. And the judge accepted that and said, yes, directing somebody else to do it counts as you doing it. So I think there was a collective, and I remember seeing that, when reading as the trial was going on, when the judge hinted that was how she was going to rule, I think there was a collective few on behalf of the Rooney team and probably a collective on Vardy's team.
Yeah. And just actually, we spoke about this very, very briefly before hitting record. But not to be confused with agency in a sense. Well, there's a number of different types of agency that are engaged. And I think, again, it's a term that is thrown around and misunderstood and misinterpreted. So the example we spoke of is Party A's got a contract with Party B. They fall out. Party B gets someone to chase them for the debt. But Party A doesn't really have to respond to this debt collector because they've got no jurisdiction unless there's a judgment that can be enforced by the court. Their contracts with Party B, and they've no obligation to talk to anyone else whatsoever, even though they might be acting as an agent. But therefore, if they do something wrong and they're acting as an agent, that's on Party B. That's nothing to do with Party A. So we had this brief chat before we came on. So the terms of agency were floating around in this discussion. But in this sense, it matters not that someone else was actually doing, as you call it, the legwork of this investigation.
Yeah, of liaising. Just to say, at some stage, we'll have to have a discussion about the difference between about assigning a claim or a debt, because that's quite an interesting subject. But back to this, So basically, what they said is, well, actually, okay, it's clearly your agent who's liaising. But what's very interesting about this is, and what went horribly wrong for Vardy is, now in legal proceedings, one of the first steps you do once all the particulars of claim and the defence are sorted, and this is one where they had lots of preliminary skirmishing, and it was, here's our claim, and we're claiming this. They put in a defence, and then it was actually, well, the preliminary hearing where they say you need to tidy it up, you need to. So in the end, Rooney's defence was a re-amended defence. Wow. Because they'd had to amend it,
re-amend,
as things. And in all fairness, no disrespect to lawyers, because this is very, very hard, and pleading is very, very hard. But the judge did pick up on it, and a few people commented and said, it could have been a little bit tidier, the defence. Yeah. Rooney probably didn't help herself at that stage. But I'm not. I personally, that's not a criticism I have. It's very. Pleading defence. The whole point of pleading defences is that all you do is you set out the facts that you need to establish to win your case. The same with particulars of claim. You don't argue law in particulars of claim defences. You don't even argue evidence. You don't say, and I've got the evidence. You just basically say things like, that is not true, or that is true, or somebody said.
The phrase I like is the facts upon which you rely, and that's it. Nothing more. And,
that's all it is.
And to be fair to the lawyers, as you say, I think the rules don't make this any easier, because the rules have got to be there. It's got to be clear. It's got to be clear cut. Everyone's got to know what they are, and everyone's got to stick to the rules for that reason. So it's a fair game. It's a fair playing field. But at the same time, the rules say if it's amended, you can't just say, well, here's the new one. Forget the old one, here's the new one. You can't do that. You have to literally scratch through, and then in different colors and all this sort of stuff. So everyone can see what it was before and what it's been amended to. And again, this is something a lot of people won't realize, that is the process of going through a claim. I've had to, the number of times I've had, especially in early practice, small claims that have come that have been sort of badly worded, with all respect, but badly worded because it just reads as a story rather than the facts as to what happened, and you have to sort of mishmash it away, but without deleting. You strike through as opposed to rewrite, so it can be quite a nightmare even for the simplest cases. But interesting tangent as always. But so we virtually
next
done with
stage is disclosure.
Yeah.
And have you got an N265?
I do.
Perfect. Almost as if we'd rehearsed this. Which we don't. If there's one thing that's obviously very clear from my performance, that this is live and unscripted. We did say to have one of these on standby. Right. I say both sides, all parties, because you could have multiple claimants and defendants. This is one of the first things that you have to do. And it's called a disclosure form. And it's fairly standard. You say who the parties are and what the case is, but then you go through, and the rules of disclosure are that you must disclose to the other side a list of any document you have that you seek to rely on, but also that may undermine your own case or may assist the other side's case. And generally speaking, just it might be relevant to the case. Now, there's a bit of a tension here because the rules on disclosure are really strict, but because disclosure is a massively complex exercise, they also say, oh, but be proportional about it. So it's where do you draw the balance between not getting yelled at for incurring too many costs on disclosure and not getting like struck out because they say you didn't comply with disclosure, which to bring in another trial, that's what's happened in the Alex Jones trial. And we'll chat about judgment and default perhaps on another video. But yes. The Alex Jones trial, he is not allowed to defend the case because he didn't comply with disclosure. So now they're just having an assessment of a trial on just what damages he has to pay. So these are very important. But you say who you are, and you give a bit of background as to, just so people know how much work you've done, you sort of list, I've only, what have I checked? I've scanned through my emails, searching on the following terms. I've had a route in the attic to see if there's any boxes. I'll just get rid of that phone.
Yeah, that's all right. Yeah, and so just to clarify with disclosure, this is not the process of sending everything to the other party. Disclosure, as it suggests, as you can see in this document, a list of documents for standard disclosure. So it is a list. You're creating a spreadsheet typically of what the document is, what it says, what it's for, where it's from, what the date is, and that sort of thing. And often the control of that document. So they come in certain categories. This is one that we have in our control and you can see it. It might be, well, we've got this one in our control, but you can't see it because it might be privileged for one reason or another, legal privilege or whatever it might be. Another list of documents could be, here's a few documents that we do control, but they're not in our possession, but we can, tell them to hand it over. Or these are documents that are not in our control and they're not with us, but we know they exist. So they're with someone else. We know they exist. They've got them. This is what it says, but we can't do anything with it because we don't control it and we don't possess it. So you can see very quickly how complicated that can get. And that was my diversionary tactic while I was
that was really good. I was just being, client care and everything. So desperately sort of messaging, going, "Hi, I'll get back to you straight away." Just to say, one of my favourite bits of reference to disclosure, and I send you it in the messages, Dan. And I don't know if you can bring that up. But
yes,
it's how much effort you do, because some people will list literally every single document. This is a really common thing in especially in the States, in commercial litigation. And a trick that people do is to list every single document, like tens of thousands, but then transpose like the reference number to a key document. So, document 1227 and call it document 1272, so people can't find or refer to it, and then go, oh, sorry, just a typo. That does happen. But sometimes people, will just say things like a carrier bag with some papers in it. I shot myself in the foot by sort of sinking me and the client to copy hundreds and hundreds, to scan hundreds and hundreds of pages, because basically one of the disclosure items was miscellaneous documents. They said, yes, we'd like those. I said, okay, I'll drop them off and you can have a look through. You can inspect them. And they said, no, scans are fine. And it's like, you sure you don't want to inspect them? It's like, no, scans are fine. It's like, yeah, so you have to be careful. But Dan's finding that because
I'm just trying to bring it in now, actually. But let's see if this opens up. Wrong way around. There we go. This is the one you're talking about, isn't it?
Yeah. And this is just a genuine comment on disclosure from a real case. It's from a case called Three Rivers, and I just like what they say about disclosure. I can't actually see that. That's too tiny for me. I don't know if you can see that.
So I'm trying to bring it in so we can. I'll read it out if I can. So you might not be able to read that, but its relevance to the case and the impenetrably poor way in which it's been listed and disclosed, and consequently made very few requests for further disclosure from the liquidators. The way in which it was listed by special dispensation of the court and at your request was very largely by box or file, thereby saving an enormous amount of time. Indeed, one of our assistants memorably looked into one box of disclosure to find that it only contained a broken chair leg. Moreover, the disclosure was given by your clients, seems in many cases to have been, and it goes on. But I obviously, the middle bit was the bit you're talking about.
Yeah, I just love that. The judge is makes a snarky comment at the end of the judgment saying, nothing, after the chair leg, nothing turned on that. It was of only marginal relevance. But yeah, so you like literally you say what you've got. As Dan said, the other side can then say, I want to see item 1, item 14, item 27, and you can either come and inspect them, or you can just ask for copies. Now, the interesting thing in this case, of course, was that Vardy's team had to put a lot in the bottom one, which is, I used to have these documents, but now I don't. And this was in relation to this series of unfortunate events involving her husband, because basically they wanted to see the WhatsApp messages, because they had sight of a couple of very incriminating WhatsApp messages that basically showed that there was an arrangement with the newspaper.
Yeah, that's this one here.
Yeah, so they had to fill this in, and they had to say, well, can we see your iPhone, because it'll all be on there? And then Miss Vardy said, oh, well, no, I've got a new iPhone, and I don't know where my old WhatsApp messages are. And they said, well, that's not a problem, because WhatsApp messages are saved. Oh, I must have archived them, and I've got a new phone. But then they did a lot of internet sleuthing. They went onto all her other social media, and apparently you could tell which phone people have been using. And they said, no, actually, past that date, you still had your old phone, because we can see that you've been using it to log in to your social media accounts. So that looked highly suspicious. They said, well, it's not a problem as well, because they're all on your laptop. But then she sent off to some expert to get her laptop analysed. And then apparently she broke it. And she said, oh, well, I threw it away then, because it was no use to the expert, because I broke it. And then both sides experts said, well, actually, we could have pulled it from the hard drive. We don't, the fact the screen's broken is irrelevant. Yeah. So they said, well, you've shared an account with your hubby, so we'll just have a look at his phone. But then it turned out he'd lost his Apple. He'd forgotten his Apple login, and he just couldn't get into his phone. Then one of the other disclosures said, well, we've got loads of witnesses at the newspaper who will say it's not from me. Now, what they did in that is she put in what we call witness summaries. And a witness summary is something that you use if a witness isn't going to be available. And you say, here's a witness and here's what they'd say. So it's not a witness statement even. It's just, if this witness was available, they'd say the following, but they're not available for certain reasons. That's a lot less common now that we've got sort of, video conferencing, because it used to be more like they're out of the jurisdiction, or they're somewhere we can't.
Yeah, we can't find them. They can't come. They can't turn up. They can't be questioned. So here's a summary of what they'll say. And even if they haven't managed to even put a witness statement in as hearsay. So as I was discussing with Andrea Burkhart, as you probably saw, the differences with hearsay. So ours largely for civil trials, it's like, yeah, we'll look at it, but we'll put less weight on it. Typically, and that will go with as long as it's served at the same time as serving a normal witness statement for someone who is going to come and turn up and be cross-examined. Someone who isn't would say, well, they're not coming, but here's their witness statement, and we'll rely on it as hearsay. But the witness summary is even lower down the rung than that. It's just a summary of what they would have said. They would have said something to the effect that we were right.
Yes, exactly. Well, that's pretty much what she said. Unfortunately, the journalist then said, we know nothing about this. Not been in touch. What you're on about. So that was an embarrassing thing to be caught out in. And then, of course, there was the final instance that said, well, it's no problem because your personal assistant has all these on her phone. And that was the famous way if she was trying to take a picture of the North Sea from a North Sea ferry. And unfortunately,
that's right. Ended up at the bottom of the sea, apparently, didn't it?
Yes. Now, we always joke in disclosure where people ask for further documents and say, you're just on a fishing expedition. And that's a term we actually use in law where people are applying for disclosure. We go, this is just a fishing expedition. And if nobody made a fishing expedition joke in the disclosure applications, I will be very, very, very disappointed. Yeah. But anyway, that was a big problem because you've got all this incriminating evidence that's just vanished. And that came back really badly in the trial because, the conduct of the trial is very interesting because the judge did comment about the witnesses. And as we've said in defamation trials, the judge is allowed to just go, I prefer to believe you than you, just the way you're acting.
Yep. They are the judge. Literally, they are the judge. And that's exactly what they are there for.
Yeah, but they can test it against the evidence as well and say, well, look, where there is some corroborating evidence or some other evidence, it tallies with what you're saying, but it's not really consistent with what you're saying. And that was a big problem for Vardy. There was very little evidence here because obviously it all vanished to the bottom of the sea and various other places. Now, what was interesting was how the judge would approach this. Would the judge, because as we've said before, judges don't like to say you are lying. It's all I prefer the evidence of. I suspected the judge might have said, well, I'm not going to speculate on what happened to that evidence, but the fact is it doesn't exist and therefore it can't assist you. So, I'll just make my decision without it. But the judge actually, albeit in very gentle terms, said, I find it likely that you deliberately set out to deliberately get rid of this evidence. And here's where the other side used the old 1721 or 1722, nobody seems to be able to agree on that case, of the chimney sweep's apprentice who found the ring in the chimney. And that case actually turned on a slightly different issue about who had good title when you found something. But another rule that was established was that if somebody goes out of their way to get rid of evidence or to not produce evidence, the court is allowed to assume that the reason they're doing that is because the evidence is really fatal to their case. And that's one of the arguments they made in this case. They said, and the judge adopted that. I mean, she actually said, I don't really need, because all the evidence I have is enough to get you home on truth. But I am also going to take into account that the only inference I can draw for you getting rid of all this evidence is it would have sunk your case even further. I mean, again, she put it in quite reasonably speculative terms, even though it was actually a finding that had happened. So basically they found that, the defence was substantially true. Yes, she had used somebody else because, of course, the personal assistant wasn't at trial. Now, interestingly, they could have joined her as a defendant. They could have gone after her, but they actually deliberately. There was both sides said neither of us are going to go after this. Sorry, not a defendant, as a claimant, but said neither of us are going after this person. And we wouldn't seek costs against them. So if she wants to come give evidence, because there's a thing, although normally only the parties are responsible for costs, there's what we call sort of Section 51 order, where a court can actually make anybody responsible for costs, even if they're not a party to the case. But if they think somehow they have contributed to the expenses of having a trial and they are at fault in some way, they can say, no, you should chip in for this. But everybody said, we agree, if this woman is called, we're not, we accept she's vulnerable mental health, and whatever happened and who told the thing, she wasn't the main player here. I mean, Vardy did throw her under a bus and say, oh, she must have been doing it all without my knowledge, which of course Rooney's team said, well, what's in it for her, selling stories to the newspaper on behalf of you, without, is it a surprise when she hands you some money? But yeah, they said, we're not going to, we're not going to really beat up on this witness, but we'd like her here. And she didn't call her. The judge said, the reason you've kept her away, because yes, I accept she's poorly, but there's nothing that you could have done a deposition. We don't really do a lot of depositions in English trials, but they are available for if a witness, is poorly or can't travel. Yeah, you could have done video link depositions or just get a statement from her. They said the reason you did get a statement for her is she's going to say, yeah, you did all this. And that was another finding the judge did. So the truth defence succeeded. However, what was interesting is the public interest defence, which was I put this out in there in the public interest, that failed. And what's interesting about that is, unlike when you're running truth, in public interest, it's not the single meaning room. So you can actually say any reasonable meaning you can put forward, you can defend. So they could have defended that we're just saying it came from her account. And what's interesting is the judge said, I accepted the story was the subject matter is a matter of public interest in this horror, the press basically having relations with trusted people and then expose their secrets. So that's a legitimate area of public interest.
The broad discussion was of a public interest, of course, because everybody would be interested in knowing, well, how would they treat this and how would they treat that and what would happen with this. And so, the broad subject matter was certainly public interest. Public interest being, of course, what the general public would be quite interested to know about. And
it's because they always say the public interest is not synonymous with what is interesting to the public. There has to be some, it can't be salacious gossip. I mean, that's interesting, but it has to be a matter of, this is a legitimate matter of civic discourse, the press's relationship with people, especially in these days of phone hacking. I
suppose another way of putting it is people need to know about this rather than people are interested in it.
Yeah, it's like you need to know how the press operate, especially. I mean, one of the things why I genuinely believe a lot of people didn't know about the phone hacking at the newspapers, and I certainly didn't, was because most of these stories do come from either the person themselves, their press agent, or their friends. Mm-hmm. So when people go, well, you must have suspected because there's all this, how did you get this person information? Usually it's their mum ringing up or their best friend. Mm-hmm. You will not be surprised to know that when people are surreptitiously caught washing their car in crop tops and things like that, it's not necessarily as spontaneous and paparazzi as might be suggested in the story.
Not quite as random as it might seem.
No. I mean, we've done this. I actually did. I did one bit of day lawyering once. I was usually the night lawyer, doing like the defamation, the contempt, and all that sort of thing. But the day lawyers deal with some of the copyright issues, and I did one where I had to draft a contract with a particular celebrity who was going to answer questions on the day, and in exchange for that, they were going to write a fluff piece. And although it's generally you're not supposed to give approval to the subjects of your material in journalism, it was agreed that her agents would have editorial final say over what was being written about this person. And I sort of wrote it, and I got a call when the actual real lawyers came back going, he said, yeah, I've seen your drafting. It says, technically speaking, it said, you gave her editorial control of the entire newspaper. And of course, such and such, through her agency, so-and-so, will have editorial control. And I went, yeah, of that one article. You just sold our newspaper to somebody else. So, again, careful drafting. But yeah, but what was interesting is the public interest defence failed because they said, although the subject was a matter of public interest, publishing the story at that stage wasn't, because you should have gone to Vardy and seen what she had to say about it. Because you don't always have to do that. I mean, there used to be this thing called the Reynolds defence that was like a checklist of what to do to succeed in what is now public interest. Give them the right to reply, double check all your sources, all that sort of thing. That's really gone now. It's pretty much because they recognise that that's not always practical. News is a perishable commodity, so you've got to act quickly. So if a story is time pressing, you literally just either publish it and find out afterwards what they say, or just ring up and say, we're going to press in 10 minutes. If you can get an email to us, we'll consider it. Something like that. But in this case, they said actually there wasn't any pressing urgency. You could have sort of just had a word with her and said, what's her account? Even if she denied it, then they'd probably be all right to publish it. Well, I put this to her, she denies it, but look, here's what I did, draw your own conclusion.
Here's what I did, here's what I think, this is what I concluded. She said no, but here it is. And then, in terms of the defence, it could have been along the lines of, well, it's of public interest because people ought to know that this is the kind of stuff that happens and the way that it happens. But as you say, it fell a little bit short of that because of not giving her the opportunity to comment on it. And there could have been other intervening factors, such as one person suggested the account could have been hacked. Yeah, the account could have been hacked. I mean, she stands by, well, she still says she's disappointed with the decision. Well, maybe
I can't help. Sorry, I can't help but think, had Vardy have got home on, succeeded in defeating the truth defence on a technicality, the judge might have come to a different conclusion on public interest. Because ultimately, judges, yes, they apply the law, and there's this whole thing about sympathy does not create jurisdiction. But
there's also a balance, isn't there?
Yeah, you've got to try and at least achieve justice. I mean, this, and it's not like it's the other way around. It wouldn't have surprised me if we had, like we had in another case recently that I'll chat about, where the person actually won the defamation claim, but then was awarded £1.
Yeah, well, I think we come back to that. I think, as I mentioned in my earlier video, I think this format of doing live streams and pre-records, this is obviously not a live stream, but live streams and pre-records of breakdowns of cases such as this, such as famous people-type judgments, and real sort of person in the street cases where, as we did with the Ashley Neal video, that seems to be popular. People seem to like that. I like the idea of doing breakdowns of cases like that. I think people do. Let me know in the comments what you think about that. If you want to see more of those, what kind of cases you want to see. I see, while I'm on this tangent, I see all kinds of very strange behaviors by companies with respect to contracts and how they treat customers, consumers, and this sort of thing. And really, the truth of the case and the truth of the matter and analysing the case. It should. This sort of law, I feel like I'm on this kind of mission that everybody needs to understand this. It shouldn't be something that you have to go and pay thousands of pounds for. You know, yes, I'm a lawyer. It's part of our profession to charge fees for services, but it's more than that. I think everybody owns this process and owns the law, and so should really understand this. So that's why I enjoy doing these, and I can speak for Alan. I know that's
same here.
Part of why you're here as well.
Yeah, I mean, because obviously we're using this case because it's quite, a famous, another celebrity case. But it's useful to know because the disclosure exercise, if you bring a small claim, yourself in the county court, you're self-repping, you will still have to do that disclosure exercise. And I think this case illustrates just the dangers of getting it wrong.
I mean, even down to filling the form in. I mean, again, with the greatest respect to everybody watching, if you are not a lawyer, you might look at this and panic and think you've first of all, you've got to fill it in. I know it looks like, but in the what, well, it's in the whichever, and it says that the prompt here, the court name. Well, lots of people, well, which court? So I've seen many a time in here, the small claims court, which actually obviously doesn't exist. I say obviously, it's maybe not obvious, but doesn't exist. It's the county court sitting at wherever, or it's the money claims centre, or and then you've got to fill all of this in and go through all this process. Obviously, for small claims, it's simplified, but you're still expected to comply with Part 31 of the Civil Procedure Rules. It's only really costs that's discounted as the normal rule for small claims. You're still expected to tell the other party what documents that you rely on, what might undermine you or assist them. So yeah, Al, you're absolutely right. I know I cut across you there.
Some courts actually are now making, because disclosure is something that even lawyers get wrong all the time. Lawyers, we're just terrified of those forms. I mean, we know what they mean, but having to fill them in is a nightmare. Yeah. And they are doing alternative orders now. I mean, sometimes in some small claims they're going, there's no disclosure. Just basically, you both put your best case forward.
Yeah.
There's another one which is literally, they call it the key to the door disclosure, which is you can just come around. There's the computer password. There's the key to the filing cabinet. Seriously, and they just say, knock yourself out.
Have a look, see.
Yeah, there are sort of and then there are different levels of disclosure on a spectrum between that. But that form is for what we call standard disclosure, which is the one that is generally used until these alternative orders came in, was, as the name suggests, the standard disclosure exercise. But now you are encouraged to use it. But like I say, you've got to get it right, because you can get sanctions for getting disclosure wrong. In the Alex Jones case, he was not allowed to defend his case for failing to comply with his disclosure obligation. In all fairness, they did give him plenty of time to comply. And they would do that, especially if you were an underrepresented person. If the other side made a big fuss and said they didn't disclose this or they've not done it properly, a judge would probably say, I can't give you legal advice. However, what they're asking you to do is, and if you were to put in that box there following, then...
Yeah. Yeah. And so just to circle back to this public interest, which I do think is interesting, no pun intended, this was the judge's comment about not accepting the public interest defence because of what you just said, Al, which is, is not reasonable without taking steps to put the allegation to Miss Vardy and give her the opportunity to respond. It's no answer to that point that she anticipated that she would deny it. Which, that'd be a fair assumption that she's going to deny it. But even if someone's going to deny it, it's like 99 out of 100. If you write a letter to someone, say, we're going to sue you for this, they'll write back and say, not our problem, not our fault, not our liability, we're not paying you or whatever. And then it's an argument, and maybe later down the line, and a good proportion of cases do settle, but not on the first letter, not on the first allegation, invariably. But that we thought you would find very interesting. Those are the two main things I think we were going to talk about. Any sort of broad sweeping comments before we wrap up?
No, I think we've covered it. But like I said, the big thing here is going to be the costs, because again, to give you something useful. There have been offers of settlement. Here's a general rule, and we'll talk at some stage about what we call cold bank offers versus Part 36 offers. But the general rule is, let's say Dan sues me for £2,000, and I write back and say, I'll give you a grand to go away, and he says no, and we go to trial. If Dan wins if Dan ultimately wins £1,001 or more of his claim,
which is very slightly more.
Yeah, however, if he only gets £1,000 or less, he's still paying mine costs, even though he won. So, and that's something that's going to come back in this trial. So that's something that, and because we say most cases settle, so you have to be very careful. And there's a lot of tactical skirmishing now about what's the best way to make an offer. What should we pitch at? Should we do it as a cold bank, as a Part 36? But to find out more about that, tune in next time. Same Black Belt Barrister back channel, same Black Belt Barrister back time. Or, of course, hopefully we'll have Andrea on in the interim. I was so envious watching you with Andrea. And I feel for your viewers that, I mean, I'm back now. You've definitely, to use the football metaphor again, it's definitely the reserve team playing today.
Well, I felt she absolutely deserves more subscribers, more attention. I mean, she's got lots of attention, don't get me wrong. She's got a great viewership, and her viewers obviously love her from the comments left against that video. But they love you too, Al. So check our channel out, which is linked, I think, in most videos now. Our art and media law, which we are just about to get really roaring with. We've got a good handful of subscribers now, so let's keep that growing. Keep subscribing to there. Lots of different videos to come on that as well. And of course, here, leave your comments as to what you want us to talk about here with regard to other famous cases and your private cases where you want us to discuss and analyze those as well. It'll be our pleasure. It'll be fun for us. Hopefully it will be helpful to you. So with that, Alan, I thank you very much humbly for your time. And everyone watching, I thank you for your time and attention as well. Remember to subscribe and like the video. And thanks once again for watching. You take care.